The Madlanga Commission heard testimony this week that Police Minister Senzo Mchunu overstepped his powers by instructing National Police Minister Fani Masemola to disband the KZN Political Killings Task Team. Now, SAP's legal expert Marga van Rooyen says that Mchunu unlawfully strayed into the constitutional competence of the National Commissioner with his instruction. But how do we determine the separation of powers between public servant officials and political principals, and how can officials seek interventions when the lines have been crossed? So Public Service Commission Chairperson Professor Somadoda Fikeni weighs in, and he joins us now. Good morning, Professor, and thank you so much for your time.
Good morning to you and your viewers.
Firstly, Professor, how does the Public Service Commission interpret Masemola's testimony that he was pressured by Minister Mchunu to disband the Political Killings Task Team?
Well, we try as a constitutional body to avoid going analysis of a current commission, whether it's hearings in Parliament or a commission itself, but stay and focus on the laws that we have provided in terms of the separation of roles. So that I can speak to the issue of the separation of roles. In 2021, Public Service Commission did issue guidelines and revised those in 2024 on the unlawful instruction and how you deal with it. But also the Constitution, as it is outlined, will state very clearly in terms of what the accounting authority, which is the minister, could do, and what the accounting officer, which in this case would be either a DG or a commissioner of police, would do. So those are very clearly stated. And where there is a doubt, we often encourage them to say, seek legal advice, whether state attorney or state law advisors, and ask them, given this particular instruction or the action I'm about to take, whose role is this? If it is about procurement issues, then you will look at the Public Finance Management Act, the PFMA, and also look at the Public Service Act, if needs be. Those clearly delineate the roles.
Sure. Professor, if Mchunu did indeed overstep what constitutional or administrative norms would have been breached in that process?
Well, again, as I said, if the law was breached for any minister in any situation, irrespective of the current commission, then the law will speak to that and say you have breached it. So it wouldn't matter whether it's Minister Mchunu or any other minister, where the Constitution says these are the roles, where the law says these are the roles, should those be overstepped, then there is a problem. Where there might have been a confusion, then commissions of this nature or courts or legal advisors would help clarify that role.
So what does this situation tell us about the separation of powers, essentially, especially between the executive, the public service, and independent oversight bodies?
There has been a problem, whether you go to the Zondo Commission outcomes or other corruption reports or other decided cases in courts. You do find that there seem to have been an overlap in terms of the roles. And those might just be due to ignorance at times, or some of them might just be due to people exercising the powers they do not have to exert the influence. And that in itself, I think, once it is decided and once it can be demonstrated, it becomes a legal matter for criminal prosecution.
So what recourse is there if someone oversteps the parameters, essentially?
If they overstep the parameters, Parliament can actually take action, reprimand, President can take action, or if it goes to the constitutional bodies. If it's a minister, as a public office bearer, the public protector can play a role. If it is a public service official, then the Public Service Commission can play a role in correcting that.
So if it is found, Professor, that Mkhunu acted unlawfully, is there scope for the PSC or any other body, for that matter, to demand disciplinary or criminal or administrative consequences?
Since this matter has been taken to a commission of inquiry, I don't think at this stage you would have other bodies such as your public protector playing a role, because mainly the public office bearers, it would be the public protector, and the parliament is also having its own hearings. So normally, in order to avoid the saturation of any case by the same state entities or constitutional bodies, we tend to defer those to the current processes and see what comes out of that.
So, Professor, what lessons should government ministers or HODs and senior public servants take from these hearings about respecting the boundaries between politics and administration?
The first one, I think we need to have a far more comprehensive onboarding process where people are trained as to what they can do, what they cannot do, what their powers are, what their powers are not. But also they can help familiarize themselves with the unlawful instruction guidelines of the Public Service Commission. And if they are still confused about certain particular interventions, they can ask the state attorneys or the state law advisors, which are provided within government itself, to say, I want to take this step. Is it lawful? Within the departments themselves, as you saw the testimony of the legal head of the SAPS, you could also tap into those legal units and say, I want to take this step. Do you think it is okay for me to take it? Which laws can I, cite when I'm taking these steps? If you don't do that, then you remain exposed and the intentions will be questioned.
So, Professor, what structural reforms or policy changes, would you recommend to strengthen the firewall between political actors and the administrative apparatus to prevent this kind of alleged overreach in the future?
Most of the laws, 90% of them are already in place. It's a matter of bringing them to the attention of the role players. But not only that, if we do have the executive being strong enough to have checks and balances and do have a parliament that will exercise active oversight whenever such reports are brought to its attention, and that in that particular way, you will have less of these incidents. But also, I will assume, even the political parties concerned, they should play a role. Issues of accountability, issues of oversight have an ecosystem that will only work when each and every one of us, from constitutional bodies to the judiciary, to the executive and parliament, play their active role. Even within the department, as I said, there are legal advisors who should actually be playing the role of advising, sometimes even if it's an unsolicited advice.
So, Professor, does South Africa need stronger laws to criminalize political interference in administrative matters? And if so, what would those reforms actually look like?
We already have very good laws in place. The question is the political will to implement them. And the question is making people aware of those and have onboarding processes, training, deep immersion, not just the normal inductions where you are bombarded with everything and anything. And that in itself, I think we can even in those workshops have the case laws, which says there was a time in life as it remained when this instruction was given, there was a time when this happened, and these are the implications. Perhaps that need to be strengthened.
Professor, thank you so much for your time.
My pleasure.
That was Public Service Commission Chairperson Professor Somadoda Fikeni.